I have great news to share with you. My client will finally adjust status with USCIS, the BIA, the Board of Immigration Appeals, reopen a case, dismiss removal proceedings to allow my client to adjust status with USCIS. This is a case dated 1997, okay? This client of mine has been order removed since 1997. Let's get right into it. My name is Bijoux Ngwanda, as you know it. I am an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex US immigration law cases. If you are new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And also don't forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and like, share. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Let's get right into it. This person get in the US entry without inspection in 1997. Subsequently, this person applies for asylum. And asylum is denied. She was in fact granted volunteer departure. However, you know, if you do not depart within that 30 days, or if you ask for an extension, then you do not depart within that time frame, then the volunteer departure order becomes a order of removal, and that is final. And therefore, you are barred from adjusting status for 10 years. But, you know, 10 years has lapsed. If you can count 1997 until this year, 10 years has really lapsed. But she just couldn't adjust status because, you know, entry without inspection, order of removal pending. USCIS does not have jurisdiction. You have to try to reopen your case, then dismiss proceedings or terminate removal so that you can adjust status. But it wasn't that easy because in order to reopen that case, well, the best way to go about it is to join ICE. Well, even though you join ICE, let's say, for example, you join ICE and ICE agree to dismiss the case. But if you don't have entry, if you don't have a lawful entry, you cannot adjust status either unless you qualify under 245I. So what happened with this person is that likely TPS was granted for her country. So, and because of TPS, she was able to get advance parole, and she was able to get outside of the United States, then get admitted with TPS and basically parole, inspected and parole. And because she showed that, and because the agreement was already going on with USCIS to allow TPS holders who made their second entry to adjust status if they qualify, right? So we had to join ICE. Finally, ICE agreed, and well, we filed with BIA. And you know, BIA takes forever to respond. This case took at least 9 months because we filed, I believe, in May of last year, and we received a response this week, yesterday actually, on Friday, March 8th, 2024. So now my client can adjust status. The reason she's going to be able to adjust status, number one, because she has a qualifying relative. She has I-130 approved. The qualifying relative is an immediate relative for the purpose of adjustment. So her husband is a US citizen. So, and therefore she can adjust status. So, number two, second reason is because now that she made a lawful entry. Remember, she had entry without inspection before. So now that she made a lawful entry with this TPS and advance parole, then she qualifies. Number three, no other inadmissibility issues, no criminal records or anything of that nature. So that's why she's able to adjust status. But the moral of the story is this: if you have been order removed or you have been granted volunteer departure and you failed to depart, you cannot adjust status with USCIS because they don't have jurisdiction. The way to go about it is to try to join ICE if they agree. And in order for ICE to agree, really, you have to have something solid. First of all, if you don't have an I-130 for an immediate relative, ICE is not going to reopen the case. They're not going to join the motion, and the judge is not going to grant it because they don't see any potential form of relief. So it has to be qualifying relative in terms of immediate relative. Because why? Because it's going to waive unlawful presence for you automatically, because you have an immediate relative, okay, and you have I-130 already approved. That's how you show ICE that you qualify. If you have I-140 employment, well, the way to go about it, you have to have an exception to show to ICE. Maybe an old petition, 245I, that was approved or was approvable at the time it was filed. Cutoff date is April 30th, 2001. And that way you can show that to ICE, and then ICE most likely will agree to reopen your case, to join the motion. And then once ICE agrees, 80% of the time, once ICE agrees, the judge will agree as well, you know, unless something else comes up, which I haven't encountered yet, okay? And what else can we say about this story? We can say that, of course, she had to go with the agreement that USCIS has currently with TPS holders, which is going to expire next year. As a matter of fact, if you are a TPS holder and you're trying to reopen your case and you initially enter without inspection, and now that you have parole, ask for advance parole, I strongly suggest that you go out and then make your second entry with inspection and parole so that you can adjust status later on, okay? Especially on the family-based immediate relative. If you don't have the agreement with USCIS like TPS holders, another way to go about it is because we have this doily memo. It's still going on, friends. This is the time you have to take advantage of it. Another person asked me on the live session that, well, can I just try to use prosecutorial discretion to dismiss my case? In order for prosecutorial discretion to work, you have to have something to show USCIS, like I have this type of relief available. I-130 has been approved. I-140 has been approved. And I am prima facie eligible to adjust status. Because if you can have I-130 approved or I-140 approved, if you are not prima facie eligible to adjust status, you will not be able to adjust status. In other words, if you have I-130 approved, but you enter without inspection, and you don't have 245I to exempt you from that, then ICE is not going to agree either. So you have to show that you are prima facie eligible, like you meet those 4 requirements for adjustment of status. That way we can convince ICE to join motion. Then depending on where your case was last heard, if it was with BIA, then we'll send the agreed upon motion to BIA. If not, then we'll send it to the immigration court. We have experience doing it. We have been successful talking to ICE. If you need help, guidance, my friend, this is the time. The doily memo is still current. This is election year. We don't know who's going to take power. Take advantage of it if you can. If you need a consultation just for a second opinion, you can schedule it. Consultation link is in the description box below. Until next time, bye-bye.